Hi, my name is Andrew Meinzer of Meinzer Law Firm PC. We take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. Accordingly, the information that I'm about to provide is based on current California law. It's general information and not specific legal advice. Today I'm going to talk with you a bit more about your heirs. Your heirs are the people who will receive your assets when you die if you don't do anything to specify the people to receive your assets at that time. This is the 8th and final video in an 8-part video series. If you live in California, then your heirs are defined by California law. And as I said, your heirs are the people who will receive your assets after your death if you have not done anything to provide otherwise. One good thing about heirs is that most everybody has heirs, so your assets likely will have some place to go other than the unclaimed property division of the state controller's office if you haven't specified who will receive your assets at your death. Now, there are a couple of bad things about distribution of your assets to your heirs after your death. First, the people who would be your heirs if you die today may not be your heirs at the date of your death. That's because those presumed heirs may die before you die, and we determine who your heirs are based on the time of your death. Further, your heirs who receive your assets after your death could be very distant relatives to you. In that case, you may not even know them. You may not have a relationship with them. You may actively dislike them. That can happen. So how do you avoid having your assets transferred to your heirs at death in California? There are 4 options in California for avoiding having your assets transferred to your heirs at death. Those options are: 1, have a properly set up trust. 2, have a will. 3, co-own those assets as joint tenant with one or more co-owners. In other words, you and other people own those assets together as joint tenants. And 4, designate one or more people to be the death beneficiary of the assets, to the extent that it's possible, depending on the type of asset that it is. The last 3 of those 4 possibilities or options have significant downsides. For example, transferring assets at death through a will does not necessarily avoid the effort, delay, fees, and other expenses of a probate decedent's estate court proceeding. I've already discussed these 4 options in our Transferring Assets at Death video series, and we'll be discussing them in more detail in a future video series. Planning ahead for transfer of assets after your death can be very complicated. There are many factors to consider, including who you want to receive your assets. Also consider how easy you want to make things for your relatives after you die. If you don't do this correctly, then you may create confusion and even conflict among your family members at your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California at death. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning and transfer of assets at death, or even if you just have a question, please contact us. Let us take care of you.